it has embedded in it this idea that the business is on the skids. It's going out of business. And so if that's the case, well, several factors come up. The first factor is, does the business have any assets? If a business is going out of business and uses the bankruptcy process to bring that to pass, the court is going to appoint a Chapter 7 trustee to the case. Now, if that business has no assets, then there's nothing for the Chapter 7 trustee to do, because the primary function of the Chapter 7 trustee is to seize the business's assets and liquidate them so that there is money to pay creditors. So in a very real sense, there's no point in filing a Chapter 7 bankruptcy if the business has no assets whatsoever. As a matter of fact, one of the judges here in the Central District of California a few years ago sanctioned an attorney, not me, sanctioned an attorney $30,000 for filing a business Chapter 7 when there were no assets to be liquidated by the Chapter 7 trustee. Now, suppose then that the business does have assets. Well, one reason why the business owner might file the bankruptcy is, I don't want to waste time liquidating the assets, distributing the proceeds to the creditors. Let somebody else have that heartache. So they file the Chapter 7 and then give all the books, all the assets to the Chapter 7 trustee and wash their hands of the whole mess. That sometimes does make sense. Now, there is, of course, the additional wrinkle that the business owner, or owners as the case may be, may have personal liability on some of the debts. So if the trustee distributes to the creditors less than they're owed, then those creditors may go after the business owners to collect the unpaid portion of the debt. One of the things that is not talked about that much is that Chapter 7 trustees tend to take a lot of the bankruptcy estate for their efforts and for the services of the various professionals they hire as part of the process. So a business owner might take the position, well, I could go ahead and liquidate these assets and pay the creditors directly and cut out that Chapter 7 trustee middleman, and the creditors would get more, and maybe they would accept this and not come after me personally. But then, of course, the business owner does have the headache of having to do the liquidation, having to contact the creditors and see if they will accept this lesser amount. And if there are lots of creditors, this can be a gargantuan task. So it really depends on the facts of the case. If there are lots of creditors, perhaps it's simpler just to let the Chapter 7 trustee take control of what's going on, with the understanding that if there are personal guarantees signed by the owners, well, there may be problems at the completion of the case. That's one of those things that requires some careful analysis. And sometimes I've had business owners give me a call and ask that very question. And in some cases, we've concluded, now it doesn't make sense to file a bankruptcy because, well, there are no assets to be liquidated. Just file papers of dissolution and then deal with the creditors after that. Other times, there are lots of assets. And, well, as a matter of fact, I remember doing a bankruptcy for a store that sold flooring. This was some years ago. And there were all kinds of different types of flooring, and this was not going to be an easy liquidation. So the business owner, who had this business for quite a few years, decided this is just not worth the time and the effort and the heartache. Let's just give it to the Chapter 7 trustee and let the trustee go for it. And so that's what we did. And the trustee had to work pretty hard to sell some of that stuff. But when it all ended, it turned out that the business owner had no personal liability because that owner had not signed any personal guarantees. So again, it's very fact specific. It's not so easy just to give well, go ahead and liquidate on your own or go ahead and file for bankruptcy. It's very much fact dependent.